Well, it's remarkable how everything dovetails at this meeting. Now, Jerry was telling you about an immunization. A few years ago, I was doing a series of talk shows in Jacksonville, Florida, and there was an attorney there who was sort of a wealthy dilettante who had his own talk show. And because I was doing talk shows there, he lit out after me, and every day he started broadcasting. He said, Eustace Mullins is murdering children. Eustace Mullins is advising parents not to vaccinate those children, and those children are going to die horrible deaths. Eustace Mullins is the worst murderer of children that has ever come to Florida. And he would go on and on and on. So I thought, he's probably trying to provoke me into suing him, you know. But so I did tape record some of this, but I never bothered to sue him because I figured that, of course, he was an attorney, so it wouldn't cost him anything. And I represent myself, so it wouldn't cost me anything, but I would have to go to Florida every time we had a court hearing. It just wasn't practical. But that's one of the few times that I did not sue when I had more than adequate provocation. But it's sort of strange to sit in front of a radio and hear somebody saying, Eustace Mullins is a murderer of children, you know, because I really didn't deserve it. But my book, Murder by Injection, was what provoked this. And it was selling very well down there at that time. So I'm going to talk to you today about the most important thing, which is how to survive in courts. Now, when I published my book, Rape of Justice, in the promotion I said most crimes are committed in our courts. Now, I said that 15 years ago, and I'm still waiting for anybody in the legal profession to answer it, because that is a very bold statement. No answer whatsoever. But being in court is quite exciting because those are our modern arenas. It's a jousting tournament. You go in there and they try to kill you, and you try to kill them. It's a war to the death. They call it the adversary system for that very reason, because you go in there to do all the damage to your opponent that you can, and you don't have to worry about morals or scruples because anything goes in court. You may have honor and integrity anywhere else, but you never have it in the court system. And that's because the court system is the total corruption of every human attribute that you could imagine. Now, my first advice to people is always, never be a defendant. Always be a plaintiff. I've always been a plaintiff. In fact, I have sued the U.S. government for so many times that the government has never once, despite a lot of provocation on my part, government has never once filed any legal action against me in the 50 years that I've been active, because I'm in there fighting them first. And when you attack them, the bureaucrats are so timid. I can't even get them to come into court to face me. So I pretty much had my way with them. But so being in court can be a very exciting thing. I used to tour with a guy named George Gordon, who had what he called the Barrister's School of Law, in which he actually trained people how to defend themselves against false charges and so forth. And George would always tell his audience, he would say, if you're in court and you're not having fun, you shouldn't be there. Because it's a lot of fun to go in and defend yourself. You're defending your own interests. And usually you're defending yourself against unjust attacks. So it's very satisfactory to do this. And I always tell people, go to a big prison and stand at the balcony and look down at those rows of cell doors, and behind every one of those iron doors is a prisoner. And just remember, every one of those prisoners had a lawyer. So you see how important lawyers are. And you know, I do a lot of legal consultation, and first advice I always give people who have a legal problem, I say, fire your lawyer. Because the lawyer is not going to do you any good. A lawyer is a businessman who is an entrepreneur who's in business for himself. Whatever a lawyer is going to do is for his advantage, not for yours. because you're a client who's going to come and go. You'll be gone after your case is over. But he's always looking out for himself. And the whole legal profession is a fraternity in which they look out for each other. They protect each other, and the public is their victims. They look upon all the public as a sheep to be shorn. And Jerry was telling you about Freemasonry and so forth. Well, the courts are absolutely the headquarters of Freemasonry. Every judge and every lawyer is a Freemason. So when you go into a court, you're going into a chapter of a Freemasonic lodge. You're in the lodge. And if you're not a member, well, you're just out of luck. And of course, most people, there are people who are Masons that go to court. And in fact, when they come into court, when they walk through the door and toward the podium, they throw their hands up like this. This is the Masonic sign of distress. So this is a Mason coming to court and letting them know that here's a Mason and they sure better help him, you know. That's just one of the little things that you... I acquired a Masonic ring once at an auction, and then I went into court and I walked right up to the judge and judge's podium, and I had my big Masonic ring, and I put it out right in front of him. But I was so dumb, I didn't realize that in a small town, they all know who the Masons are, and they knew damn well I wasn't a Mason. So it didn't do me any good at all. But whenever I start to be clever, it always backfires because the other people are more entrenched and they know what they're doing, and I'm just an outsider looking in from the outside. But the legal profession has a great defense against people like me who represent themselves. They say, a person who represents himself in court has a fool for a lawyer. Well, I've been in the courts for 50 years, and I've had more court time than most practicing lawyers. And from my own experience, I can tell you that I have modernized that statement very simply, and I say that anyone who hires a lawyer is a fool. Whatever a lawyer can do for you, you can do better for yourself, believe me. And the legal system is not that complicated. They try to make it very, very arcane. And of course, it's a Babylonian system. What we have goes back 5,000 years. And of course, Freemasonry originated in Babylon too. So you're dealing with the same entity. And we have achieved a system of justice in the United States, and I'm sure here in Canada also, from Ernst Zundel and his tribulations and many other people. It's a system in which justice has slowly been totally driven out of the courts. One of the most famous lawyers in the U.S. is Jerry Spence. He's been on television a lot, and he's not too far from here in Jackson, Wyoming, and he has a big law building there. The biggest building in Jackson, Wyoming occupies an entire block downtown Jackson, Wyoming. And Jerry Spence wrote a book a few years ago called Justice for None. And the first line of that is, there is no justice for anyone in an American court. And it's absolutely true. There is no justice. So why would you go? Well, you go there to do combat with your enemies. You don't go there for justice. If you're looking for justice, you're wasting your time. What you do is you go in and fight them, and either they beat you or you beat them. And you have a damn good chance of beating them if you're not intimidated by the system. And I have one other tried and true slogan, and that is, never be a defendant, always be a plaintiff. And I've always been a plaintiff, and I have very seldom been sued in my life, because if you are ready and willing to go to court, people are not going to sue you. They don't want to sue you. Also, I sue lawyers, and lawyers don't like to be sued. There are many areas in the United States where you cannot find anyone, any lawyer, who will sue another lawyer. Called professional courtesy, you know, defeating sharks and all that. And they will not, I don't care how much money you offer them, they will not sue another lawyer. So I have, as I say, I've sued lawyers who have attacked me and who've tried to injure me. I don't go around looking for a lawyer to sue. But I had one lawyer, there was a side benefit which I didn't know about for years from suing lawyers. And I have a lawyer who teamed up with a relative to try to steal a lot of money from me. And so I sued the relative and the lawyer together. And so it dragged on for a couple of years. And that's another important thing about lawsuits is give yourself a liberal time frame. Don't expect anything's going to be over in 6 weeks. It may be 2 years or 3 years or 10 years. But just stay with it and you'll get there. Because the whole idea of the legal system is to discourage you, to impoverish you, and to force you out of court by simple attribution that you have nothing left and you say, well, I can't go back to court, I haven't got a dime left, so I'm finished. And so by continuing to fight, and of course when you're your own lawyer, the only expense you have is the filing fee. You do have to pay that. And of course a lot of the prisoners who file most of the suits in the states, prisoners sign a vow of poverty, and they don't have to even pay the filing fee. So they flood the courts with lawsuits, which is wonderful, because the more lawsuits, the better. Because the whole system is absolutely ridiculous anyway, and the more suits that bog it down, the better it is. So I always file suits without even a second thought. I say, I got to sue that guy. And so I type up the complaint very quickly and take it right down and pay the filing fee, and I'm in business. I have launched my new ship, you know, and it can stay afloat a very long time. Of course, my advantage, too, in law is that I've been a professional writer and researcher for many years, and that's all law is writing and research. There's very little argument in law. In fact, in England, you know, they have a separate lawyer for a barrister and a separate lawyer to argue in court. So what it means is you pay 2 lawyers instead of 1. But in the States, your lawyer also argues your case in court. It's a one-shot deal. But they do very little court appearances because a lot of it is settled out of court, and they have the legal system where they head you off before you ever get to court. You always ask for a jury trial, but you very seldom get one because it never gets to court. And another very helpful thing to know, and I have trouble getting people to do this. I say if somebody sues you, immediately file a countersuit. And they don't want to do it, and they always have a lawyer, and the lawyer doesn't want to do it because now he's arguing 2 suits for the price of 1. The suit against you and the countersuit. So the lawyer will always say, oh no, we don't want to do that now, we'll do that later. And so there, your best counterattack, your countersuit, your own lawyer denies you that. And they always give a perfectly good explanation. Say, oh, it'll confuse the judge if you bring in a countersuit, and let's get rid of this, let's go through this process, then you can have your countersuit later, which is total nonsense. What you want that countersuit for is you're now counterattacking. Remember, you're at war, and you're attacking the enemy, and the enemy is attacking you, and your countersuit is your counteroffensive. In fact, my slogan as lawyer, I've always said, my strategy is I'm attacking on all fronts. And that's what lawyers do. They attack you on all fronts. They try to destroy you every way that they can. And this Babylonian Freemason system is totally violating of the Constitution. And one of the first things they do is the discovery process. Now, the Constitution of the United States guarantees your right to be secure in your papers and your possessions. The first thing the Babylonian system does is, under discovery, they demand that you bring forth every piece of paper that you have ever acquired in your entire life and turn it over to the opposing lawyer for their inspections. And then they go through this with the fine-tooth comb, and they try to find something they can use against you. In other words, you're required to incriminate yourself, which again is against the Constitution. You're not supposed to have self-incrimination. And the Constitution says you're secure in your papers. No, you have to turn all your papers over to the other side. And this is how the tobacco lawsuit and the Texaco lawsuit in the States, they got these enormous judgments against these companies, $146 billion against the tobacco companies, because they made the tobacco companies turn over all of their private records, and then they went through them and they would take little things out of context and say this is incriminating. And they persuaded the juries, who are very easily persuaded anyway, they don't know anything. The only way you're chosen for jury duty is to make sure that you don't know anything. I have never been asked to do jury duty because I'm too smart. And I'm immune anyway because I am a practicing lawyer, although I just represent myself. And if you're a practicing lawyer, you cannot be called for jury duty. And if I was ever called, I would plead that because I always have cases going on. And you cannot go and sit at jury duty if you're a lawyer and you've got to be in court tomorrow on another case. So it gives you a nice exemption. And because some of these court cases will drag on for a year and you go down there and sit as a jury duty, sometimes you're not even on the jury. You have to be there as an alternate jury. And it takes up a whole year of your time, and it's totally wasteful. But one of the things that judges are most afraid of is contempt. They're afraid you'll be contemptuous of them because of the contemptible things they're doing to you. And there's the old saw that the judge says, "Sir, are you showing your contempt for this court?" And the guy says, "Well, no, Your Honor, I'm trying to hide it." And you do have to say Your Honor. I always say Your Honor. And I do it, and I try to do it without laughing, but it's not always easy. But my legal experiences, I must say, have been the greatest fun of my life, suing lawyers and so forth. And this one lawyer that I sued, the case dragged on for almost 2 years. And we were down on motions day. They have what they call motions day. You go down to the judge's chambers, and the parties argue motions against each other. And so this lawyer came up to me while we were waiting to go into chambers, and he says, "Mr. Mullins," I said, "Yes." He said, "Can't we do something about this lawsuit?" And I said, "Well, I'm doing all I can. You know, I'm not." And then, for good measure, I threw in, I said, "Well, you know, I'm not really a lawyer myself, and I'm not sure what I'm doing, so that's why we're not making more progress, see?" And I admitted my guilt. I was the problem in the whole case. He says, "Well, you know," he says, "ever since you filed this case," he said, "my malpractice insurance has doubled, and it's costing me $10,000 a year just to have this case going." And I said, "Gosh, I'm sorry you told me that. That makes me feel so bad." And I was trying not to laugh, but it was one of the best news I ever heard in my life. I didn't realize you had this wonderful side benefit that when you sue a lawyer, you really cost him a lot of money immediately. It starts coming right out of his pocket. And it's just something that you don't expect. Sometimes this little manna from heaven comes down, and you're not even looking for it, but there it is. And in fact, that poor lawyer was so desperate. He finally settled with me. He came to me and he said, "Just draw up an agreement, anything you want, and I'll sign it." So I did. I signed on my own terms. You know, people have said to me over the years, "Well, Eustace, do you ever win a lawsuit?" Well, you win every time you go into court to defend your own interest. You're winning every minute that you're in there. It's a winner. So don't ever let anyone persuade you that it's a waste of time to go to court. It's a needless expense. Because believe me, you're fighting for your life and your property. When you go into court, everything's at risk. Every asset that you have, your whole life ahead of you, it's placed at risk because of this diabolical Masonic system that you go into. So you need every protection you can get. Now, there's always the problem of what to call yourself when you defend yourself. For years, we used attorney pro se, and then we used pro propria persona, that is, you in your proper person. But David Miller came up with a new term a couple years ago called citizen in party. A citizen in party having first-hand knowledge of the facts. And I've used that ever since. And it's really helped me in court because I find that the judges are very impressed by this. You're a citizen in party. And I think it throws them a little bit. They're not sure. You know, judges and lawyers are very uncertain of themselves. they never are quite sure what you're up to when you're not a lawyer. Because, see, they're all a fraternity and they work together. And your lawyer and the opponent's lawyer always work together to give you the best screwing you ever had in your life. But when you don't have a lawyer, you take away their greatest advantage. The judge doesn't know what to do with you. The other lawyer doesn't know what to do with you. And they're thinking, gosh, this kook is coming in here and he's messing up our whole system. And it is. It's a beautiful system. It's a system for robbing people. Being a professional lawyer, a member of the bar, means you have a legal license to steal. You have a license to rob everybody that you come in contact with. And believe me, they don't miss the opportunity either. So every time I've gone into court, I've won, and I've won quite a bit. In fact, I have judgments against the FBI today entered in federal court, one for $35 million and one for $50 million. And I haven't collected them because I have so much fun having those judgments, and I renew them every year with the FBI and the IRS just to let them know I'm still around. I got those judgments in '82, and I got them because after many years, I got copies of my FBI file. And I didn't ask for them for many years because I thought, how could I have an FBI file? I've never even had a parking ticket in my life. And my friends would say, Eustace, you must have an FBI file. They must have a lot on you. And so finally, I wrote to them, and they answered, said, yes, you have 800 pages. And that was 500 pages more than John Dillinger, the most famous outlaw in American history. He only had 300 pages. I had 800 pages. Well, of course, I was very interested in this, and so they said to do it for 10 cents a page. So I sent them the money, and then they began to stall, and they wouldn't send it to me. And for about a year, they stalled me. And finally, I wrote to Senator John Warner of Virginia, a classmate of mine in college, and I said, the FBI hasn't sent me my file. And, and 2 days after I wrote to John Warner, I had a knock on my door just at dusk, and there was a guy standing there, and he thrust his package into my hands, and it was my FBI file, and he ran away. I couldn't even tell you what he looked like. It was very furtive, but there I was with my FBI file. Well, I opened it up and started reading it, and it was great reading. I put 120 pages of my FBI file in my book, A Writ for Martyrs, which explains how federal agents harass private citizens. And so a lot of it is marked out with black ink, you know. In fact, I was on a radio show in Dallas, and I showed the interviewer a couple of pages of my FBI file. It was all blacked out and marked. You couldn't see one word on it. He said, oh, yes. He said, freedom of information. That's what you get when you deal with the FBI. Now, when you go to court, they have to produce the unmarked file. But so, of course, when I sued the FBI, because in my file, I found out in 1959, J. Edgar Hoover had personally ordered me committed to a mental institution. Now, J. Edgar Hoover was not a psychiatrist. He was a guy that needed a psychiatrist, but he wasn't one himself. And he ordered the top 5 assistant directors of the FBI as top priority to see to it that I got committed to a mental institution. Of course, I knew nothing of this at the time. And there was Clyde Tolson and Al Belmont, and the top 5 people under J. Edgar Hoover were all ordered to drop everything else and make sure that they got me into a mental institution. He didn't tell them how, because he didn't know how, but they did cook up a scheme finally with the Chicago office where I was living there, that they would bring me before a Cook County judge, and the judge would commit me to a mental institution. Well, Providence is always in there working overtime, and a few weeks before they were going to do this, I took off for Michigan to write the biography of Ezra Pound. A friend gave me a cabin up there, and and of course I didn't tell anyone where I was going. I loaded up my car and drove out of Chicago, and so the FBI had informants all around. In fact, they used to come banging on my door every day, and I wouldn't let them in. And so I never once opened the door for him because I was there by myself. And a team of FBI agents comes in. They could say that I met them with an assault weapon and they had to shoot me down, you know. You have everything to lose and nothing to gain by dealing with these people. So after I went to Michigan, J. Edgar Hoover panicked because he figured that I had been tipped off and that in revenge I would probably come to Washington and kill him. So he issued a national alert for me. They had FBI agents at every bus station, every airport, and train station in the United States. And their only mission was to be sure that if I came in, I was to be apprehended at once. Well, I was traveling by a beat-up old car that I bought for $100, so I had no reason to go to any train station or anything else. And they had not a clue as to where I was because I had never gone to this place in Michigan before. And weeks went by, and they still did not know where I was. And they still had the national alert out for me. And J. Edgar Hoover was still expecting me to come to Washington and shoot him. Although I had no gun at that time, it would have been a little difficult. But they don't take those things into consideration because under J. Edgar Hoover, the whole FBI operated under total fear and paranoia, reflecting his own condition, you know. And so there I am sitting up there in Michigan, typing away on the biography of Ezra Pound. And it was summertime like this, beautiful weather on the lake. And so the uncle of the owner of the cabin, he and his wife wanted to go down to Chicago for a weekend and go to a play and nightclubs and so forth. So I said, why don't you go and use my apartment and you can bring my mail back. Of course, I had not forwarded mail or anything. And so they drive up in the alley behind my apartment, and as they got out of the car and went upstairs, I was on the second floor, to go in the back door of my apartment, a number of FBI agents jumped out, shining lights in their face, and they all screaming, "Where's Mullins?" And the supervisor, they were scared out of their wits, because in Chicago, you don't know whether FBI agents are mafia or what, you know, and just plain robbers. So they said, well, he's up in Michigan at Lake McCosta. They said, okay, and they disappeared. Well, when they were upstairs, the FBI had grabbed the keys out of their car so that I couldn't drive off. They figured it was me, you know, and that I would be taking off, so they grabbed his keys. And so the guy had no keys to his car. They left because they got what they wanted, but they didn't give him his keys back. So here he is stuck in Chicago on a Saturday night and no keys. And he started calling around. And he finally got somebody to come and make a pair of keys. So they were so disgusted they drove all the way back to Lake McCosta. And the next day, Russell told me what had happened. So, well, before that, when I was awakened the next morning at dawn by somebody rapping on the door. And I looked at it, and three very well-dressed, they were very senior FBI officials, had flown up there, and there they were knocking on my door. And I said, well, what do you guys want? And they said, can we come in? And I said, well, I wouldn't mind your coming in, but I said, this cabin is lent to me, and it's full of stuff of the owner. And I said, when you come in, you steal things. So these FBI agents were very apologetic. They said, well, will you let us in if we promise not to steal anything? I mean, they're very reasonable people, you know. And so I said no, and I talked to them through the door. And I said, what do you guys want anyway? And they said, well, we just wanted to know about Verna. And I said, well, what about Verna? And they said, Verna was the nurse who nursed J. Edgar Hoover's mother through her last illness. And Verna was not troubled by Edgar's habits at all, but his mother, on her deathbed, called J. Edgar Hoover and said, look, I only want one thing from you, Edgar, and that is, will you promise to give up Clyde? And Edgar said, well, Mother, if that's what you want, I'll do it. And, of course, he had no intention to do it and didn't do it. So what Verna was horrified by was that he would lie to his mother on her deathbed, you know. And she really was put out by that. So she told me about this, and I knew her quite well. And she was a figure around Washington, an amateur writer, a nurse, and various things. You have a lot of people floating around Washington like that. And so this is what they were referring to, Verna's connection with Hoover. And I said, well, no. I said, you've been misinformed. I said, go back and get me some more information, and maybe I could talk to you. But they were so relieved to know where I was, because J. Edgar Hoover was going out of his mind, wondering what happened to me. And they left immediately, and of course, radioed in that they'd found me and all that. But I didn't know what was behind all this till later, till I got my file in 1982. This was in 1959. So after I got my file, and I had 40 pages of memoranda from J. Edgar Hoover and FBI officials about committing me to a mental institution, which is about as big an invasion of privacy as you can have, even if I was crazy, which of course I was writing books like crazy, and I wasn't showing any mental aberrations of any kind. And so I filed suit against them, and I didn't know it at that time, but the government has a policy when you sue them of not answering, of deliberately going into default. Because under the court system, they figure you can't do anything anyway, you'll get a default judgment. And under federal court procedures, a judge does not enter a default judgment. You, the plaintiff, enter the default judgment. So I went to the clerk of the federal court with my default judgment for $35 million was the first suit, and entered it, and it's been on the books ever since. Never challenged by the government. So a little while later, I thought, well, I need to sue them again, so I sued for $50 million on the same grounds, and since the other had not been adjudicated, see, when a case has not been adjudicated, you can always reopen it. I'm reopening a case in Massachusetts where I was, a summary judgment was decided against me a couple of years ago. And I got to thinking about it, and I decided to reopen it, so I filed a petition to reopen. And under our legal system today, the lawyers have set it up so no case ever really dies. You can keep a case going the rest of your life. And it costs you nothing, because once you pay the filing fee, everything else subsequent to that is covered by that fee. So you can file as many motions as you want. You can make as many court appearances as you want. There's just no limit to it. And you're in command. That's why I say be a plaintiff. By being a plaintiff, you totally direct the course of the case, how long it's going to last. You can always voluntarily withdraw the case if you feel like it. But it's up to you. And the defendant is always at your mercy. So here I had the FBI absolutely would not answer. They went into default on the $50 million. So I filed the default judgment on that. So I now had default judgments against the government for $85 million. And people gave me advice on what to do. One of them said I should put a lien against the White House and charge the president rent for staying there, which I very well could. But what I wanted was the Library of Congress. That was my old stomping ground. And I was going to file a lien against the Library of Congress. And I still might do it. And all these things are open to you when you're a plaintiff. And these are also alternatives which your lawyer will never suggest to you and would stop you from doing, just like they stop you from countersuing. Why does the lawyer do this? Because the lawyer is your worst enemy. He's an officer of the court, which means he's subservient to the court. You hire the lawyer and you pay the lawyer, but the lawyer is an officer of the court, and he has to be respondent to the will of the court, has to be respondent to the bar, which he's a licensed member, has to be responsive to the judge and to other lawyers. So it's them against you. You're always the outsider. I don't care how you come in, how much money you spend, you're always the outsider, and your interests are the last to be considered. Now, one of the most revealing things about the legal system is what's called ex parte judgments. Ex parte means without the parties. Most legal work does not appear in the courtroom or happen in the courtroom. It happens in judges' chambers, in secret meetings between the lawyers for the parties and the judge. They sit there, and you're not present. They sit there and decide what to do with your case, what to do with you, how to divide or award your property to somebody else, anything. It's all ex parte. You know nothing about it, and you're advised of it some later. Sometimes they don't even tell you what they've done. But ex parte judgment shows the Babylonian system of the court system. It shows Freemasons meeting privately to make a Masonic judgment on your fate. And they will not advise you. They will not tell you anything on this. And you find out the hard way when some judgment is rendered against you, and you wonder, how in the world did they ever come to this totally unjust judgment? They came to it as a conspiracy. It's a conspiracy against you, and you're the victim. And you have little recourse. You call up your lawyer. He doesn't return your calls, by the way, and complain about this, and you can call him for weeks, but you'll never get a response, because what's he going to say? Look, we double-crossed you. That's all he can say. That's his only defense. But by representing myself, you see, I short-circuited the whole system, and that's what you do. So no matter how unprepared you are and how scary it is, believe me, when I first went to court on my own, I was pretty nervous. And a friend of mine who was a lawyer was sitting there, and the judge looked at me and he said, do you want to file a motion? Well, I didn't know what a motion was. I'm sitting there on the lawyer's bench. When you're your own lawyer, you sit up with the lawyers. And it's strictly forbidden for anybody else to sit there. So I'm sitting there on the lawyer's bench, and the judge says, do you want to file a motion? And I had no idea what a motion was. And so this guy came over and said, he wants to know if you want to file a paper. I said, oh, yes, I'll file a paper. I never did, but anyway, I agreed to do it. So that was the only help anybody ever gave me in court. Now, the American Bar Association states specifically that when you represent yourself, the judge has an obligation to step in if you are at a loss as to how to proceed or what to do next. The judge is supposed to advise you. Do you know what happens in an instance like that? The judge says, I am not allowed to give legal advice. And that is an absolute lie. He's obligated to do it. But he says, I am not allowed to give legal advice. And I have never had a judge help me in court in any way. Except one time. The other side, because you're representing yourself, what they hope to do is to stick you good by not only ruling against you, but then awarding attorney's fees to the people you're suing. And they can stick you for $30,000 or $40,000 attorney's fees. So I had sued the city of Stanton on a case where a guy ran into my car and tried to kill me. He was assigned to kill me. And he came at me with a big Lincoln and hit the side of my car and smashed it in. But I had a big Oldsmobile, which was just as big as this car. And all it did was dent the door. Didn't hurt me at all. And so then he got out and said, he said, look, my insurance will take care of everything. And he drove off. Well, he called the police, and then he drove off. So the policeman came up on his motorcycle, and he was a big, mean policeman, one of the meanest policemen you ever saw. And he said, where is Mr. Snyder, the other guy? I said, well, he drove off. He said he couldn't sit around here waiting on you all day. If you were so slow, he was just going to leave. And, of course, the policeman turned flaming red, and I said all this very innocently. I was trying to be nice, help him out. And so the policeman, of course, then became my chief witness. And the case dragged on. And finally, we were ready to go to trial. And we were going to go to trial on Monday. On Friday night, this policeman was taken, a big healthy guy, was suddenly taken to the hospital with some ailment or so, and died within minutes after getting to the hospital. So there went my witness. And I'm sure they murdered the guy because, as I say, I had an open and shut case. He had run into me. The guy had left the scene of the accident. Everything was going for me. And but without him, I was alone at the time. I had no witness of any kind. So we went ahead and had the trial. And so at one point, the jury went out to look at my car. The side was smashed in where he had hit me from the side. And the jury came back and deliberated 8 minutes. And, of course, they had the jury stacked against me. I didn't know that. They always put somebody on the jury. So the jury deliberated, and they came out with their conclusion that the accident had been my fault, that I had backed into him. Now, how I backed into him and smashed in the side of my car, they didn't explain, but they ruled against me, and I didn't even feel it because it was so ludicrous. I had had my fun. The case had lasted almost 3 years, so I had had my fun anyway. Oh, by the way, they also brought out during the trial, during the discovery, that the guy that ran into me was legally insane. He was under a medication for insanity, which affected his driving and so forth. So I had everything going for me, but the jury ruled against me. That shows you the importance of a jury trial. But that was just one of my experiences. But I have had some great experiences in court where I absolutely destroyed the lawyers and put them to shame before the court because they screw up a lot. And in fact, I always had a lot of fun with my law because being a researcher, I love to use the Oxford English Dictionary. And the Oxford English Dictionary is full of citations in Old French and Middle English, which of course are totally undecipherable to anybody in the world. And I put these long quotations in. And it drives the lawyers crazy because they don't know what it means. I don't know what it means either, but I don't tell them that. And so finally, a couple of lawyers went before the judge, and they also complained that I was putting Latin statements in my briefs. Well, Latin was the original language of law, you see. And so the judge agreed, and he ordered me to stop using Latin quotations in my brief. Order from the judge. And so I obeyed it for a few weeks, and I started putting them back in, and nothing was ever said about it. And but this is just one of the things that I did, having fun in law. But the lawyers themselves, they're very incompetent. Now, even Chief Justice of the United States, Warren Burger, appeared before the American Bar Association about 20 years ago, and he chided them. He said, you know, 30% of all lawyers in the United States are totally incompetent. Because he was complaining, because as a Chief Justice of the Supreme Court, they saw cases come in that were poorly prepared, had the wrong citations, and this is very annoying. The Supreme Court's a very august body, and to have this junk coming in and presented to them as arguments, it was very frustrating for them. So he told them that, and I would say today it's up to about 50% because they're getting worse all the time. You know, lawyers are not taught any law in law school. I had a lot of fraternity brothers who were law students, and they deliberately don't teach them anything because the law firms that hire them, when they get out, they don't want them to know very much because they want to indoctrinate them in that firm's proceedings, the way they do things. So they come in with a clean slate, and they become very good members because they learn to do what they're told to do, and they do things just the way that law firm wants done. So a graduate lawyer is a guy that doesn't know any law. My niece married a guy who was going to University of Virginia Law School. Of course, I had lots of action going at that time. And occasionally I would ask this guy, Dean, I'd say, I'd see him at my brother's house, and I'd say, by the way, Dean, I've got a motion on this, so what do you think about it? And he would give me a blank look. He hadn't a clue as to what I was even talking about. And I found this very strange. Here's a guy, a law student at one of the best law schools in the world, and he doesn't know anything about anything, and still doesn't probably. He went into commercial law and made a lot of money in real estate. But he himself agreed he would never practice law, and he never did. He just went into a very specialized field and did very well at it. He worked hard, but he made a lot of money, making $1 million a year now, and one of the best law firms in the United States. But he still doesn't know 1/10 as much law as I do because he never practiced law. How do you get to know law if you never go into it? I don't think he's ever been in a courtroom. But one of the greatest treats that I had was once a month the judge of the court will have motions day in his chambers. And the lawyers from all over the state come there with their motions, and they argue the motions. And the other side argues against it. And it's very cut and dry, very perfunctory. You're in there a couple of minutes, you read your motion, I want so-and-so. The other side says, no, we won't, we oppose that. And the judge then gives a decision. Well, when I went there on motions day, I would have motions that were 10, 15 pages long, And we would sit there arguing these motions. And here you had $400 an hour lawyers piled up outside all the way around the building, right? And thousands of dollars going to waste while I'm in there arguing these motions. And I didn't realize what an obstruction to justice I had become. because all I was doing was, arguing my own case. And so finally, they tried to frame me by seizing all my property. Oh.
Your hand.
Oh, I'm sorry.
All righty, you're on.
All right. Now, the history of law in the United States is very interesting because it was a very simple profession up to 1900. You only had one law book in the United States. It was called Kent's Commentaries, and it covered everything, and that's the only law book that lawyers needed to know. And there weren't many law schools. Most people read law in another lawyer's office. And all you do is sit there and read Kent's Commentaries and go with the lawyer to court and see how he argued his motion and so forth. So that all changed in 1900. And what happened was, with the Eastern European immigration, the American law courts switched over, and I'm sure the Canadian courts too, they switched over from this very simple, basic law to Talmudic law. Now, Talmudic law comes from the Kahila, and it's a totally different ball of wax. Has nothing to do with human rights, has nothing to do with justice. It's simply a mechanized system for imposing the will of the court on the litigants. And that's all it does. It imposes the will of the court. And that's why they brought in the process of discovery, that you had to turn over all your papers to the other side, total violation of the Constitution, and totally illegal, because what they would do is try the case through discovery. In other words, the opposing lawyer would go through your private papers, pick out what he could use against you, and go to court with that, and he would have a very good case. So the jury never got to hear the evidence. In fact, I gave due notice to the court in Massachusetts, where I have a case going for 10 years. I do a lot of civil rights cases because, I'm standing here talking before you. This doesn't happen very often because a lot of times when I am going to give a lecture, and they announce it and on the radio and the papers and so forth, by the time I get there a couple of days later, someone has organized a tremendous campaign to prevent me from speaking. The lecture hall has been taken away. There's always a front page newspaper story denouncing me, and because I am pretty dangerous. Jed Hoover called me the most dangerous man in America because I was dangerous to him. He was absolutely right, but I wasn't dangerous to anybody else and never have been. But he really considered me a real threat. And the strange thing was that during the years that I was, that Jed Hoover had me under daily surveillance for 33 years, I spent all of my time in Washington at the home of a high FBI official, who was an old friend and great admirer. He was also a great admirer of Jed Hoover. He thought he was a great guy. But finally, they called this guy in and they said, well, of course, we know that your friend Eustace has been staying at your house, and he was only about 8 months from retirement. And they said, if you let him back in your house once more, you will never see your pension. And the guy didn't have that kind of money. He needed his pension to retire on. So he asked me to meet him downtown, just beyond the Justice Building. And he said, Eustace, I've got some awful news. I said, what? He said, well, they've told me that I must break off all contact with you until I retire. And he was so shamefaced, because he was a very honorable person. He was so shamefaced about this. I said, well, H.E., don't feel bad about that. I said, this is not your decision, someone else's decision. I understand that, and I certainly don't criticize you for it. And so he was very relieved, and I said goodbye, and I didn't contact him until he retired. And after he retired, I went back to staying at his house because he was getting his pension, everything was taken care of. But this is the kind of bureaucratic dictatorship that you have in Washington. Total subservience to, it's like military discipline, really. You cannot criticize your superiors. You cannot go over the head of your superiors. Your whole career is passed under this discipline, and at no time can you ever go beyond it. If you do what they call the whistleblowers, if you become a whistleblower, you become immediately the most hated person in the area. Like Ted Gunderson told me yesterday, he was kicked out of the Association of Retired FBI Agents, which all FBI agents belong to, and which is considered a very good society to be in, and they're proud of being FBI agents, and they're proud of being members. They kicked him out because he criticized some things the FBI had done. And so that's no reflection on him, that's a reflection on them. And I think he told you, too, standing here, that his former associates in the FBI were spreading rumors that he was homosexual, that he had embezzled money, and so forth. This is standard procedure. They do this. In fact, at one point in my 800 pages, they stated that I had homosexual tendencies. What they were, I have no idea, because they didn't elaborate, you see. But so I'm still in the dark on that. But the worst thing that they said against me in the 800 pages was that Eustace Mullins is a very sloppy dresser. That cost them $2 million to find that out. All they had to do was find out I bought all my clothes at thrift shops, and of course they don't usually fit well. They don't look that good. They're okay. They'll keep you warm, but they don't look that good. And they used to take pictures of me. I'd be walking through a yard, and somebody would jump out of the bushes and take pictures. So I figured, well, this is my publicity agent. You know, I can't complain. So they had lots of pictures of me. They always had my current license plate file. They say Eustace Mullins, 49 Plymouth, license so-and-so. And I'm sure they thought that I was a real sort of intelligence agent myself, or an espionage agent, because I had a Virginia driver's license, and I lived in Chicago, and I had a Kentucky license plate. Well, the reason I had a Kentucky license plate was you could get a license plate in Kentucky for $3 through the mail, and in Chicago they were $15. So it was simply a matter of saving $12. I mean, I had no particular association with Kentucky, but a lot of people used to do that. They would buy all their state license plates from places like Alabama and Kentucky for $2 or $3, and in New York and Illinois they're $15 or $20. So every little bit helps. And so there's always a very mundane explanation for these things, but the FBI like to think there was some sinister conspiracy in my driving on a Kentucky license plate. And this is what their work consists of, mostly is details like that. And so anyway, I finally pretty well straightened out things with the FBI, because I went to court and got my judgments against them. And after that, they pretty well let me alone, because the bureaucrats don't like to lose. And I had trouble with the IRS for years, and they would call me in for an audit and that sort of thing, and then they would say I owed a couple $100. So finally, I went to U.S. tax court, and all of my friends would tell me, don't go to U.S. tax court because the judges are all ex-IRS agents. So I went on to U.S. tax court, and well, first I sued the IRS, because I got a notice from the IRS that they were calling me in for an audit and to bring all of my papers down to the IRS office. And so I read this over, and I thought, well, this is a very frightening thing. It's really terrifying. So I filed suit against the agent for $350,000 for terrorism. Well, nobody had ever done this. So the district director of the IRS, he immediately told my friends, he said, they asked him, oh, his cousin took him out to dinner, and she said, and she was a friend of mine, she said, what's this about Mullins suing you? He said, oh, everybody knows Mullins is crazy anyway, so don't pay any attention to it. We don't pay any attention to it. Well, they finally ruled that I had a tax deficiency after about a year. And meanwhile, I had filed motions before the court to suspend all income tax collections in the United States until they decided the very important legal points that I had brought up. Well, they didn't want to suspend income tax collections, so they didn't do it. And I thought this was a logical thing to do, because if they're stealing from me, why should they continue to steal from everybody? I'm a very sympathetic person. I like to help other people. I thought, just let everybody stop paying taxes till we resolve this situation. It's a legal matter anyway. So they didn't agree, and finally a federal judge ruled that I had a tax deficiency. So I immediately filed with U.S. Tax Court. And I was corresponding with the lawyers from the IRS. The head lawyer of the IRS assigned all the papers to me, Malcolm B. Morton. So after about a year of corresponding, finally we were scheduled to appear in tax court. And I thought, well, now I'm going to finally meet Malcolm B. Morton and see what kind of a guy he is. Well, when I went to tax court, I looked around and there was nobody there. The IRS would not send anybody into court against me, because I had filed a stipulation with the tax court judge that I wanted the IRS charged with conspiring to put me in a mental institution, because in my FBI file, they had papers that J. Edgar Hoover had ordered my income tax returns from the IRS and so forth, which showed conspiracy. So they weren't about to get into that. So when we went in, and the judge was a very stern-looking guy, and he called the case Mullins versus Internal Revenue Service. And I stood up and I said, Your Honor, I said, before we begin the case, I think we should review the stipulations that I have before the court. And he looked at me and said, Mr. Mullins, this court does not have time to go into all that. And of course, I already knew there was no IRS lawyer, and they had a little U.S. attorney there, a young guy. And he said, I want you and attorney so-and-so to go into a conference room, and I want you to work this out. So I said, okay. And so we went into a conference room, and I had prepared a long list of my expenses, gasoline and meals and so forth, over the last 3 years. And I'd done it in all different color pencils and inks and so forth, different pieces of paper and all this. So it looked very good. So he looked at all this. I worked at it, you know. I want to do things right. And so the U.S. attorney looked at all this. He said, well, he said, actually, he said, your deductions do exceed your tax deficiency. And I didn't have one receipt or anything for all that. All I had was these papers that I had scrawled the night before, sitting while I was watching television. So we came back out before the tax court judge, and he said, have you gentlemen reached a decision? And we said, yes, we have. And he said, what is your decision? And the attorney said, well, we have found that Mr. Mullins has no tax deficiency. So I walked out of that court with a signed letter from the U.S. tax court judge that I had no tax deficiency. I reprinted it in a couple of my books. It's in Writ for Martyrs, and it's in Rape for Justice. And that was in '82, and I have never heard from the IRS since. And so people ask me when I lecture, say, Eustace, what do you do about your taxes? How do you handle paying taxes? I said, well, I pay anything I owe. But I've never heard from them that I owe anything. So I said, they never call. So I'm not hiding. I'm in the phone book, and but they never call. It's a little disappointing in a way. But I mention this simply to show you, after all, as I say, I'm not a lawyer. I have no legal training except what I've undergone myself. But appearing in court is the greatest legal training in the world. Because they're going to throw everything at you that they have, and you either win or lose. Mostly I've won. Like I say, I have my default judgments. They don't bother me anymore. And I do give legal consultations to other people. I tell people, call me anytime. People call me up and ask me about legal problems. And my friends say, well, you don't know who you're talking to. Those are probably agents. And I said, they probably are, but I don't care. And I give them the information, and they can do with it what they want. But like I say, civil procedure is so simple. You only have to do 3 things. You deny everything, and you answer everything. And as long as you do that, you stay in court. That's it. I just gave you a whole law course. But the last few years, I've done a lot of civil rights cases because I say I've been denied freedom of speech and the right to speak many times. And I had a friend named Bo Greitz who has a radio program, and he went up to Cape Cod, and he came back and he said, Eustace, there's a bunch of guys up there, and one of them owns a chain of restaurants. He said, I was up there and I was wined and dined, champagne, the works. He said, you ought to go up there. I said, well, it sounds very tempting. So I contacted these guys, and sure enough, they said, come on up and speak. So they put out flyers. They call themselves the Freedom Forum. And I was to speak at a Greek Orthodox church. The Greeks, of course, are very prosperous up there. They have restaurants and they have lots of money. And they built this enormous, beautiful church, which had a lecture room. So they put out the flyers. So then the newspaper attacked. Cape Cod Times did a front page story on me. Notorious conspirator is going to speak in Centerville, which is Centerville, Massachusetts, which is the next town from the Kennedy compound. And so so they put pressure on the priest to deny me speaking there. And the priest said, I can't do it. It's a commitment. We've already agreed, and I have no grounds to stop it. So they got desperate, and they started calling him up and saying they were going to blow up the building if he allowed me to speak there. And, of course, under that pressure, he caved in, and he announced to the paper that I would not be speaking. So I sued the Cape Cod Times, and when I sued the Cape Cod Times, I realized that it was owned by Dow Jones, the Wall Street Journal. So I sued the Dow Jones Corporation in Virginia. There was a Dow Jones Corporation in Virginia. Well, we went before a federal judge in Virginia, and he said, Mr. Mullins, I have no jurisdiction over this. This is a newspaper in Massachusetts. And so what do you want me to do? And I said, well, I'll sue under jurisdiction. So he moved the case up to Massachusetts. And so my suit against Dow Jones Corporation went right to Massachusetts, Barnstable, Massachusetts. And so they had no intention of ever hearing the case. So they finally dismissed it. And so then I reopened it, because you can always reopen a case. I reopened a case recently that had been summary judgment against me a couple of years ago. And I reopened it on the grounds that I was ill at the time of the judgment and could not respond, could not appeal, which was absolutely true. So I got that going now. And of course, that's the last thing they ever expected, is me to reopen that case. And the judge hasn't answered. Of course, the other lawyers answered, and they're very indignant. This is illegal, and you can't do this, and all this nonsense, which lawyers' responses to pleadings are absolutely primitive. They usually have no logic, and it's just like a fit of temper. Darn it, I'm not going to let you do that. That's the whole idea, you know. And so they're so incompetent when it comes to matters of law. They seem to have no respect for law, but of course, being a Freemason lodge, they don't have to have any logic to what they do. So I eventually had 3 civil rights cases dismissed in Massachusetts. So I sent due notice to the court, and I pointed out that I had had 3 civil rights cases dismissed in Massachusetts, denial of jury trial in each one. So I still got one going on, because one case where they got summary judgment against me, I refiled against 3 other people who were involved. I knew the judge was going to rule against me in a few weeks. So I hastily wrote a complaint against 3 other defendants who were involved, who had not been mentioned in the original case, and drove up there and filed it with the court when it opened at 9 o'clock in the morning. And so after they filed a summary judgment against the Berkshire Eagle case, then I still had the case against these other people. And so then I amended that complaint. I developed cancer, by the way, and I amended my complaint to include the fact that they had caused me to have cancer by all the terrible stresses that they had subjected me to, and that cancer was caused by stress. Well, let's put the lawyers into orbit. They'd never heard an argument like this in their life. And that's still going on. And now the judge has taken it under advisement, which means he's absolutely terrified and doesn't know what to do. When a judge takes a case under advisement, it means you won't hear from him for at least a year or maybe 2 years. And So I just get busy with other things, you know. You don't sit around waiting for the judge to do something. You get to file some other suit. I got a couple of other. On July the 2nd, my hometown newspaper there in Stanton, Virginia, interviewed me, and they called and said, we want to interview you about Revelation Books. Revelation Books is an imprint under which I published The Curse of Canaan in 1985. It was totally inactive, and so they listed me as one of the leading hate groups in the United States, Revelation Books. So this girl called me up and said, I'd like to interview you about Revelation Books, and I was totally mystified. What was there to say about Revelation Books? Well, she brought in this report from an outfit called Southern Poverty Law Center, which claimed that I was one of the leading hate groups in the United States. That is, Revelation Books was, not Eustace. So I very patiently explained to her that this was all untrue, that there was no hate group, and there was no members, no newsletter, and it was a Christian publishing company, which was inactive. And so she went away, and I thought they would never print it because there was nothing to print. Well, they came out with a front page story and a lot of stuff from Southern Poverty Law Center that I had been lecturing before all of the leading hate groups in the United States, listing none of them because there weren't any. I mean, this is the only hate group I've been at lately. You'll probably be called a hate group after I've been here because. But the guy that ran the Southern Poverty Law Center is a guy named Morris Deese, and he has been so successful, he has raised $500 million cash from suckers through promotions that he's going to fight hate. And, you know, fighting hate is not that hard. You just go out and fight it. And you might have to spend $500 million, but at least you're doing something worthwhile, you know. So I wrote an expose of him about 4 years ago, and what Morris Deese was doing was counterattacking me for writing this expose. Because, of course, he never answered anything in it. Because what I did, I found his court papers in his divorce. And in the court papers, his wives said that he had urged them to go out and have sex with everybody because he wanted to get rid of them so they wouldn't claim his $500 million. And then he also was caught in bed with a homosexual. He just wanted to try it, apparently. And this is all court documents that I'm quoting, see. So this was all published and circulated over the United States. And Morris Deese never answered, but he bided his time, and he was going to lay it on me, and he did with this article. So this is actually one of the most blatant attacks on me yet, that I lecture before recognized hate groups, that I have a hate group myself, and which is non-existent. So when I get back, of course, I'll be filing more lawsuits. I'm going to sue for $9 million and $9 million punitive. I always sue for punitive damages because, after all, you suffer a lot when they lay this stuff on you, and mental anguish and suffering is something that has to be atoned for. I have a lot of mental anguish. I may not look it, but but what I have done is show up the legal system for the totally inconsistent and ridiculous charade that it is. And here the judges and lawyers have been bringing people in for years and stripping them of everything they had. And they also, by the way, for people like myself, they have a special punishment called attorney's fees. And I sued the city of Stanton once of this accident where the guy tried to kill me. They had two black women who came to be as prospective jurors, and the lawyers for the opposition immediately shot them down and got them out of there very quickly. And because black women tend to be very generous in the judgments against insurance companies, and lawyers know this, so they hustled these two black ladies out, and they weren't on my jury. And this was the jury where they said I backed into the car and smashed in the side of my car. So, after this case was over, I sued the city for discrimination, for not allowing the black women on the jury, which, you know, was a very hot issue at that time. And so we went into federal court, and of course the judge was not very sympathetic at all. But I noticed that the attorney for the city kept jumping up and saying, Your Honor, attorney's fees, attorney's fees. And the judge would look at him, and the judge was no friend of mine, but he said, no, I'm not going to award attorney's fees against Mr. Mullins. And the guy would jump up a couple minutes later, attorney's fees, attorney's fees. And he'd say, no, I'm not going to award attorney's fees. So I got to thinking, why is the judge not going to award attorney's fees against me? Because he's no friend of mine. And I finally realized that when you represent yourself, that the other side cannot assess attorney's fees against you greater than your own fees, which in my case were none. So I've been using this ever since. So if they ever want to assess attorney's fees against you and you represent yourself, you realize they cannot do it, because apparently under procedure you cannot assess attorney's fees against a litigant which are greater than the other side's attorney's fees. And I've been writing on that ever since. You find out these things as you go along. That's why I say when you go into court you win, because you find out things you would never know otherwise. And I've been using that, and of course I'm using cancer and I'm using everything because you use what is there. But the lawyers get so frustrated with me because they called in my witness in this case in Massachusetts for a deposition, and I was a little worried about it because he's very naive and had no legal experience. I knew they would make mincemeat out of him. So I flew up there to be there when he was there, and after I got there I looked at the summons for the deposition, and it said Stephen May, who is the plaintiff's witness, is hereby summoned to, the plaintiff hereby summons him to this deposition in the offices of the defendant's attorneys. So I looked at it and I said, well, that's kind of odd because I'm not holding this deposition. So when I got there, I asked the attorney. He started off asking questions, very hostile to my witness, and finally May said, Mr. Mullins wants to say something. Well, so I said, Mr. Pessolano, I think we're here under false pretenses. He said, what do you mean? I said, well, this says that I, the plaintiff, am holding this deposition. I have nothing to do with this. He said, let me see that. You know, like he'd never seen it. He had signed it. He had read it and approved it. He had two attorneys in his office signed it and approved it. He looked at it. He saw right away. He said, oh, clerical error. Well, go ahead. And I said, well, I beg your pardon. I said, we're here under false pretenses, and it would be illegal for us to proceed. And his face turned absolutely black with hatred of me. And he said, point well taken. And he closed down the deposition. So then they tried to summon May back again, but they got the wrong address, and the time expired, and they never did have the deposition. But that was the most humiliating experience that guy ever had, was for me to call him down. Now, you see, another lawyer would have been gracious and said, yes, clerical error, let's go ahead and proceed and just ignore it. But I said, no, it's illegal. It's false pretenses, which it was. The summons was totally false. It said I was having the deposition. I had nothing to do with it. So always be prepared to object, speak up, defend your own interests. And that's the way it's done. And that makes you a lawyer. You are now a practicing lawyer. You can go into any court in the United States. And as I say, deny everything and answer on time. The time limits are very important because the courts are absolutely ruthless towards people who represent themselves. If you're a day late, they'll throw you out. Now, if you're a lawyer, they'll give them a little grace. They say, well, okay, we'll give you a couple of days extra. But if you represent yourself and you miss the time limit, believe me, they will rule against you every time. Because after all, you're the enemy. They want to get you out of there any way they can. So I think I'm running a little out of toward the end, but I'd like to have a few questions from you. I know you've all had legal problems from time to time. And as George Gordon says, surviving in the courts not only is an absolute necessity, but it can also be a hell of a lot of fun.
I was taken to court by Revenue Canada, and my husband defended me, Bruce Steller. I agree with you. It was amazing the amount of incompetence was
yeah.
mind-boggling. It was very enjoyable. It was fun. As a matter of fact, when my husband was finished with the 20-year auditor, I felt so sorry for her. I went up and gave her a hug. I felt so sorry for that woman. But we had a mistrial because the judge took us in the back room with the prosecutor to tell the prosecutor how badly he was doing.
Oh, yeah.
And he used that to get an apprehension of bias.
Oh, yeah.
So I was wondering if you would sue the prosecutor for that.
Oh, you certainly could, because it's improper, illegal activity on his part. He's liable for suit. See, any prosecutor or public official can be held responsible for their actions. There's nothing in any statute which says that anybody can act illegally. If they go beyond the bounds, they're just as liable as you or me or anybody else.
He got caught doing a few little things there during that trial.
Well, they usually bend the rules. They get so used to it, and they do it,
Yeah.
and nobody ever says anything because they're afraid to do anything about it.
Yeah.
And they get used to getting away with it. They get very sloppy and very careless, and they leave themselves wide open.
Yeah, it almost seemed like a conspiracy to me.
Oh, it is conspiracy.
Yeah.
It's conspiratorial. After all, it's a Freemason lodge
Yeah.
operation.
And the Crown prosecutor seemed very worried about what we were going to do from that point on. He was
I'll bet, yeah.
trying to explain himself at the end of the trial. After the mistrial, he was trying to explain how his intentions were really honorable. He wasn't, we're looking at him going, we don't want to hear
They
this.
probably never had an honorable intention.
Yeah.
But there's no statute of limitations on that. It comes under conspiracy. You can open that case anytime you like.
Yeah, I was thinking about that.
Statute.
What do you think, Bruce?
Yeah, one of my secrets is I use conspiracy all the time, because, and it is a conspiracy, because that abrogates the statute of limitations. It doesn't matter how many years have gone by, you can always reopen this case, and it's just like a new case right then.
One of the legal issues that I've been wondering about is that I'm a dancer, and as a result, I sometimes frequent particular clubs. And a couple of the issues that come up, which I'm stuck at how to deal with, is one, people blowing smoke in my face, and secondly, music that's so loud that's causing permanent damage to the patrons. And so I'm wondering, is there a possibility of turning to the legal system or filing law? Could I be the first person to file a lawsuit for this type of thing, or how would you recommend I proceed?
Well, there's been a lot of suits in the state on secondhand smoke and also loud noise. So it's actionable on either count or both counts. I would sue on both counts, damage and suffering from eardrums and from secondhand smoke.
Secondly, when I went through my marriage separation, my first lawyer was probably the most popular lawyer to represent men in Vancouver, but extremely incompetent. And when I talked to my lawyer friend, when she found out that I had him as my lawyer, she said, get rid of him immediately. But that was a little bit too late. There was a lot of damage done. And I'm wondering whether it's might be still possible to file a lawsuit against him, and even actually a lawsuit against my spouse's lawyer for the damage that was done to my child, for example.
Yeah. Oh, very much so. As I pointed out, when you file a malpractice suit against a lawyer, it costs them a lot of money, so they don't like to let them lay around. They'll probably try to settle with you pretty quick, because they don't like that against their record, that the suit has been filed, and also they have a good chance of losing, because lawyers lose suits against them in court because nobody likes them anyway, and they know they're incompetent, and that all the allegations are probably true. So lawyers have a very bad record for losing in court, so you've got a very good chance on that. And I must say, divorce law is one of the great gold mines of the legal profession, because once a couple decides to divorce, what they should do is have arbitration and come to an amicable agreement to divide up the property, because when each side goes out and hires a lawyer, then it's the duty of those lawyers to stir up the wife and husband against each other, make them hate each other bitterly, and make sure that they're so mad they'll never get over it, and then they become putty in their hands, and they can start a war, and the result is that the lawyers wind up with all their property, they wind up with nothing, and they hate each other, and it's just a total disaster. But that's the way lawyers work. Lawyers also in the States have a great habit of when a good-looking young woman walks in and she's going to divorce her husband, the lawyer realizes she's defenseless and alone, and usually takes her back in his office for a private consultation. And so things take their course from there. And lawyers are notorious for this. So they take advantage of women terribly. And this is one of the things that they do, one of the illegal and improper things they do. So their treatment of women is almost as bad as the medical profession.
I really enjoyed your talk. I've got a question for you. On civil law in Canada here, law of contract, now they're taking it to arbitration. Prior to that, they will put it to mediation, where they try and get you to agree between yourself.
Yeah, arbitration,
And, yeah, and they do this before it goes to court. Now, what would be your comments on that, procedure-wise?
Well, the problem with arbitration or mediation is that you agree to be bound by the conclusion before it's heard. So you're committed once you go into it. I've never gone into arbitration myself because I prefer the court arena and a chance to show off my legal talents. So I would never do that, but it certainly can help, and it's a shortcut, and it could save you some time and money. It would depend entirely on the circumstances and the case itself.
Two quick questions for you, Eustace. Thanks very much. The first one, you made a statement during your discussion about the fact that a judge is obligated to give you legal advice. What is the basis of that? Is that
that's the official rules of the American Bar Association.
Okay.
Because, well, for many years, nobody ever represented themselves in court, so it wasn't an issue. And people started doing this in the last 25 years, and the American Bar Association had to address the situation. So they came up with the very logical conclusion that, yes, the judge is there as a referee of the parties. And as a referee of the parties, it's his obligation, if a litigant doesn't know what to do, that he should give him a little push in the right direction. But they refuse to do it, and the judges say we cannot give legal advice, which is a total lie. And I never got any help from a judge, which was probably a break for me, because I went out and did it myself, and that was worked out the best all the way around. But they are obligated. You can, well, of course, you have the Canadian Bar Association. They probably have the same rules, but you could point out that the obligation is for him to help you.
Okay. That leads in perfectly to my next question, because you've talked about the American Bar Association and the Canadian Bar Association.
Yes.
And I would like you to confirm that indeed the word bar stands for British Accredited Regency. Is that correct?
Oh, yes. This all comes out of England, and that's why I was talking about the London connection and the Bank of England, because our CIA, our intelligence agency, was conceived right in London by Lord Mountbatten and 3 members of the British General Staff. Our Evangelical Association came out of British Secret Service in 1848, Lord Palmerston. So everything that we have is really second-hand. It comes through England first, and so what we should do is just have a queen and be done with it. You know?
Thanks so much.
Surely.
Thanks for coming, Houston. It's great to have you. I have a question for you. I've got the Tyrants from Revenue Canada. They invited me to court, and they've got a lot of documents on me, and I don't think it's really, well, I know it's not in their jurisdiction to even have it in their possession. How would I turn that tide to be the plaintiff on that?
Have they filed charges against you? Are you a defendant, are you?
Yeah, for not filing.
For not filing, oh yeah. Well, there again, well, once you become a defendant, it's very hard to switch over and be a plaintiff, unless you go into another jurisdiction and file against them as a plaintiff, which you can do. You could actually, you say they're Canadian and you're what, U.S. or?
I'm a Canadian.
Well, you can file in your own jurisdiction against them, and it's amazing what a countersuit will do. It reverses everything. That would be my advice. Countersue them in your own jurisdiction, and they'll probably drop the whole thing.
Okay, thanks for your time.
Sure.
Hello, Eustace. I have one quick comment and then a question to leave you with. 1990 Thompson decision in Canada's federal court system, Superior Court of Canada, was upheld in 1996, upheld in Ontario Court of Appeal 1990 ruling in the Thompson case. It's a matter involving a corporation. That criminal acts in Canada are not fundamentally illegal. There's only a penalty if you get caught,
Oh, yeah.
but they're not prohibited.
Not prohibited. That's interesting.
And so that's something that I find quite interesting as well, so I wanted to share that with you. And also, David Windmiller you referred to, or is it another David Miller?
David Wingmiller. Yeah,
Can you elaborate on your relationship with his personally or his
Oh, it's not
procedures?
personal. We
His
write for the
procedures?
same papers, contact. But I found a lot of David Wingmiller's conclusions were very good, and some of his stuff I could use. But fundamentally, I found in dealing with internal revenue and dealing with the courts, it comes down to your individual decision as to how you're going to defend yourself and use the particular elements of your own situation to do it. Like I say, I went after the FBI and RS for conspiracy to put me in a mental institution. And if you look at your situation, you can always find something you can use. Just examine it very closely and figure out what's going on and how you want to go about it.
So this question's on, it's a domestic issue. If a plaintiff enters an action against you, and as a defendant, you wind up getting orders in your favor, and subsequently the plaintiff decides to drop the action, does that nullify the orders that the defendant achieved?
Generally, yes. If the plaintiff drops the action, it's called a non-suit, then that voids the decisions usually. Because
Right.
the decision was only made because a plaintiff made a complaint. Once that is non-suited, then it's no longer applicable.
So all the orders that were in place as a result of whatever the defendant got in their favor would have been nullified?
Well, now, if it's a court order, that's a little tricky.
It would be a court order.
It's a court order. Now, it could be that the court order would stand, because that's a judge's order. And so a non-suit might not affect that. That's a local judicial issue, which I'm not qualified to say. But in other words, you're not going to comply with the court order because the plaintiff is no longer a plaintiff.
No, perhaps if I may, I'll try to give a quick update.
All right.
I'm a defendant in a domestic issue, and what I had won is joint custody.
Oh, joint custody, yeah.
And now I'm just concerned if the mother of the child winds up dropping what she entered, would that nullify the fact that I got joint custody through a court order?
Well, a court order on custody would usually stand, so I would look
Okay.
into that to see. It's possible that you could ignore it, and you also might be ignoring it at your peril. So
No, I want it. I'm just
you won
concerned
the
that
cus-
if she drops it,
Oh, you
I
won the
lose
custody.
my right to joint custody. That's what I'm concerned about, because I want what I won.
Oh, you want the court order.
I want the court order.
Well, go ahead and comply with it then and see what
Well,
happens.
I was only, I was only concerned is because of the fact that she had lost through this process, that as a plaintiff, if she drops the case, do
Yeah.
I lose what I had won?
No, you don't lose that. No.
Okay.
No, once she's out of it, she's probably not going to bother you anymore, and so you probably do whatever you like.
Okay, thanks.
Yeah.
Hello, Eustace.
Hi.
Are you familiar if there's any interface between UCC and Canadian law? If there's like a worldwide interface between these? Because I understand UCC is fairly worldwide prolific, and I wonder if there's any interface that you might be aware of to being able to bring UCC into Canadian court.
Oh, interspace?
Sorry? Interface.
Oh,
There's some sort of an
interface.
interface with UCC to be able to bring that up into Canadian courts through some sort of an international loop or international
Oh, I think
law.
so. If a situation has legal validity, it would be valid either place.
Yeah, because I find that United States is codified so much, and there's just so
yes.
many potential avenues to make attack because you have just a huge voluminous amount of information to go with. In Canada, it's very limited.
Oh, yeah.
We don't have the same offenses in many areas that we could utilize, and yet the UCC is full of it. and to be able to grab a UCC and bring it up into Canada and use the premise of it as a basis of a lawsuit
very
in
much
Canada.
you can do that.
Yeah.
And law, always use everything. Don't overlook anything.
Shotgun.
It's there to be used, and use it.
Okay. Thank you.
Fair enough.
A gentleman before me made the unusual comment that in Canada it's not illegal to for an agent, a government agent or a court to perpetrate illegal acts, and I'm going to elaborate on that. About a year and a half ago, I went into the twilight zone with an issue. I bought a piece of property. I purchased a piece of property which, after the fact, I was told I could not do anything with other than to log because it was in forestry reserve. I pointed out that land titles didn't indicate that, and I was told that it didn't matter, that a forest reserve didn't require land title registration. So I checked land title, and land title says that it is the indefeasible authority of designation. Indefeasible can't be taken away.
Oh, yes.
So I inquired further, and I was told that an order in council, which Bruce Steller tells me is a goofy term, gave them the right to do this. So as I was arguing with them, they didn't want to argue with me, so they sent me the actual legislation. The legislation said this, that the Forest Reserve Act was in effect whether it was in land title or not. And in the event, and I remember this because I read it about 100 times, in the event of a mistake, a delay, an omission, or a misfeasance, wrongful use of authority on the part of an agent or agents of the Crown, that any loss would not be borne by because of the mistake, delay, omission, or misfeasance would not be borne by the Crown.
Oh, yes. Yeah, that's standard. That's absolutely untrue, but they get away with it because most people don't challenge them, you see. You got to challenge everything.
I said I would go in front of the judge, and of course they asked me politely if I would consider making an application to have it removed, which I did, and they did, and it's over.
So you took care of it. Well, that's what you have to do. You have to defend yourself. Don't expect any white knight on the charger to come in and rescue you. You got to do it yourself, and you can do it. It's not that complicated, but we have been so brainwashed. We think we have to have a lawyer to do anything, and once you hire a lawyer, your troubles start. Because your lawyer's in business, he wants to make some money. So he's not looking for a quick solution or an easy solution. He wants to keep you in court a couple of years. When you represent yourself, it's all right to stay in court for a couple of years. But when you're paying a lawyer, it's a different proposition.
Anybody else? Sure. Okay, come on in.
I have a judgment rendered against me and without my knowledge, and it's from my former divorce lawyer. I had a proceeds upon the sale of my home to pay off the account, and I had sold the home, but it was anyhow. The whole point is that last June he had sent me a writ of summons. I did my own statement of defense and never heard from him. And this June, unbeknownst to myself, he had supposedly served documents stating that to come to court for a judgment. Anyhow, I had already moved out of the home. The home had sold May the 1st, and they supposedly had served these papers June the 2nd. On June the 19th, they had the judge do a judgment against them, and interest accrued. So I wanted to know, being it was a year ago I did the statement of defense, should he not have responded in a time factor, 3 months or?
I don't know about the time factor. You say this was the lawyer was trying to collect payment for services?
Yes,
Yeah.
yes, for the divorce.
Well, actually, the courts are not that tough on payment for lawyers. They know most of it's unjustified anyway.
Oh,
So
right,
I wouldn't be in any hurry to pay it. I'd look into it further.
right.
But don't rush down and pay it because you may not have to pay it at all.
Well, what I would like to do is, the fact is that I was to pay him upon the proceeds from the sale of my home,
Good.
And I had moved May the 1st. And the thing is that the statute of limitations in our area is if they're not paid within 6 years, you know, they can't collect.
Oh.
And 6 years was up on May the 12th.
Oh.
And this happened, like he served the judgment, or they brought me notice, but I wasn't there. I didn't live in the home anymore,
Oh, yeah.
you see. So anyhow, what should I do? I mean, he's stating
Well,
he's the plaintiff.
if you were not living there, it's up to him to find you and to serve the judgment. So I don't think you have any liability there.
Right, except they got the judge in court on June the 19th to sign this order.
Oh, he has signed an order, yeah.
So, like, I want to motion to set it aside or appeal it? Or
I would appeal it, definitely.
Right. And when I do that, should I just continue on with their court language or go it by the truth, in the truth?
Well, go by the truth, yeah. And on appeal, you just put in the truth and see what happens, because on an appeal like that, if it's not justified, they will generally drop it anyway.
Okay.
Yeah. See, it's all intimidation.
Oh,
what
it
they
is.
what they hope is you'll go ahead and pay it. I mean, anybody sends you a bill, and you think, well, I'm obligated to pay it whether I owe it or not, and people do.
Right.
But if you don't pay it, then usually you sort of forget the whole thing.
Good. Okay, thank you.
I just want to share a bit of information that I learned about the justice system. And apparently, when a judge addresses a jury, he's supposed to tell them that they have a right to rule on whether the law should be upheld as well as whether the person is guilty, and that they're not doing that. Do you know anything about that?
Oh, absolutely. This is a big issue in the States as well as in Canada. The judge should instruct the jury that they have to follow the law, but they never do. And they violate the law when they do that, because that is absolutely mandated that they are supposed to instruct the jury on those grounds, and they never do, because actually what the judge wants to do is control the jury. So he's certainly not going to tell them, be independent of me, because that's contrary to his purposes.
Is it not also true that even if they found that the person was guilty of the act that they committed, that they could choose that the law should not apply in that particular case?
Oh, certainly, yes.
Yes, I was just wondering if in Canada we have a court of discovery. Do they have that in the States too? Is that correct?
No, discovery is an early part of civil procedure, and you go through that before you go to trial. So it's not a separate court. I never heard of a separate court of discovery, but I can understand it could be done.
Well, and then they have the grand jury in the United
the grand
States.
jury, yes.
But are they trying to make some changes in the grand jury right now, or is there lobbying to? Because I understand that 99.9% of the cases that go before the grand jury end up going to court anyways.
Oh, they do, because you see, the grand jury in the States, I don't know what it is in Canada, in the States the grand jury is the prosecutor's realm. He only brings a case before the grand jury that he knows is going to result in an indictment. And he controls the grand jury. The grand jury doesn't know what's going on, but all they're doing there is rubber stamping the prosecutor's indictment.
Okay, thank you.
Just one more question, Eustace. I'm under the impression that the term justice means outlaw.
Well, I don't mind. My name Eustace means justice in ancient Aramaic, so maybe that's why I'm an outlaw. I
think that's what it's called. It's defined as outlaw, outside the law, outside of the law.
Uh-huh.
So,
well, there is a
Justice
term
Institute.
in jurisprudence, English jurisprudence. Frederick Law Stimson says that they force you out of the law by these very complicated and lengthy court procedures, and eventually you run out of law, and you become an outlaw because you have no law left. And so there's that aspect to it too. Yeah, they have the term outlaw, which was during the 19th century in American jurisprudence was used, that a person was out of his law, he's an outlaw.
It's like you mentioned John Dillinger, the outlaw.
Oh, yes.
Yeah. Well, justice means outlaw, outside the law. That's
okay.
Hi, Eustace. I just got one question. Have you ever, by representing yourself, have you ever seen where a judge has blatantly broken the law And would you know how, or have you ever tried to arrest a judge when this has happened?
I have never tried. I run into a lot of people that say arrest the judge, indict the judge. I have never done it because when you are to ask a judge to recuse himself, because when a judge has to recuse himself, they usually refuse to do it anyway. But if a judge recuses himself, he makes sure that his replacement is even more prejudiced against you than he was. So it's jumping from the frying pan into the fire.
Is it possible or is it lawful to bring your own tape recording device into court?
That varies. I do. In fact, whenever I went to court, I made almost a circus of it. I would take a whole table and set up copies of all my published books and 2 tape recorders. And, and I sort of build a fort, and I'm sitting there behind it. They can't even see me. But no, I believe in show business, you know.
Last question.
Hello once again. I was wondering if you had a similar scenario in the United States as in Canada. I was involved with helping an individual in a criminal suit against Revenue Canada. And when it came time to final arguments, the judge said, look, just hand us in written submissions, which was, I thought, fairly beneficial for the fellow who was representing himself. And so I helped him with his written submission. But the order was, we submit first, then the prosecutor would have an opportunity to review our argument, counter-rebut our submission, and that was how it went into the court. And I thought that was sort of asked backwards, quite frankly. They're the ones who brought us there. They're the ones who's charging. I would have thought that they would have been obliged to lay out their submissions, and of which we could determine whether or not there's any merit to it and take it apart. Is that a typical order in the States as a defendant in a criminal prosecution? You submit first, and then they have opportunity to rip apart your case?
No, that's absolutely wrong. That's very prejudicial to the defendant. And you can object to anything. It's excessively prejudicial to the defendant. You should object to it. You should always object very promptly to any illegal procedure like that. File your objection. The court may ignore it, but at least you get it on the record. Now, let them know that you're ready to fight. That's the whole thing.
No, in this case, I'm not quite aware of that being the case. Judgment's been laid down already, so there's many appeal points.
Oh.
Would that be an issue of appeal that you would consider?
Oh,
as well?
very much so.
Yeah.
That's grounds for appeal. Prejudicial to the defendant.
Okay. Thank you.
Yeah, file that.
One more.
Eustace, could you comment on Lyndon LaRouche organization and their inability to bring Clinton to task on some of his escapades?
Well, it wasn't that they were, I'm very familiar with Lyndon LaRouche's operation. And so what happened was Lyndon had some lousy lawyers. I knew one of his lawyers, Ed Vieira, who was a very fine lawyer. But Lyndon hired some $1 million lawyers in Washington. And when you hire $1 million, you're going to prison because for $1 million, they're going to see to it that you go. I mean, your defending attorney is going to send you to prison. So, in fact, Ed told me that Lyndon's lawyers filed a writ of habeas corpus, which was one of the most poorly written legal documents he ever saw in his life, these $1 million lawyers. So he was pushed aside. Lyndon was sentenced to 15 years. He wrote a book about it called Railroad, in which he showed how he was railroaded to prison by the federal judge Albert Bryan, who a number of my friends have come up before Albert Bryan, and he is the railroad judge. I mean, you go in on the fast track right to the prison. So, so Lyndon made every mistake in the book. He wound up doing 15 years in Minnesota prison, and he did 5 years of hard time. And he's the same age I am, and he's looking for another 10 years of his sentence. And so he got desperate, so he let them know that he was willing to talk business. And so they said, well, if you will defend Clinton, this was when Clinton, all the hoopla was on Clinton. So they said, well, look, we'll let you out right away, but you'll have to defend Clinton in your paper, the American Federalist. So Lyndon said, okay. So they let him out. He didn't have to do 10 years. And immediately he comes out with these 3-page spreads about how Clinton is a white knight who has never done anything wrong. Sexually, he's as pure as the driven snow. And that every charge against Clinton was manufactured by MI6 of British intelligence in London. Well, this was the goofiest thing you ever saw in your life. But he continued to print these stories, and that was his payoff for his release. So it was a straight business transaction. And how anybody can read it without laughing, I have no idea. But he sort of eased up. I think he more or less committed his part of the bargain by those stories. Whether he's still doing it, I have no idea. But I think he still does occasionally refer to MI6 cooking up all these charges. And MI6, I doubt it even knows who Clinton is, you know, because they have their own agenda, and the President of the United States is not one of it. But his whitewash of Clinton was so absurd. I've never seen anything as goofy in my life. Lyndon does some absurd things because he considers himself a cult leader. He double-crossed me once because when I did the new edition of my Federal Reserve book in 1982, a friend of mine donated $1,500 to LaRouche, and he agreed to inaugurate the printing at his annual meeting in Washington. So I drove up there with 30 cases of my books, and then they wouldn't let us in the building. They took the $1,500 and then wouldn't let us in. So he's a real phony as far as I'm concerned.